Daily in our lives, we reach agreements. Some of those agreements constitute what are called contracts, but others do not. There is certainly a distinction between agreements that qualify to be called contracts and agreements that do not qualify to be called contracts. My name is Philani Lithandane Ndlovu, and I'm certainly hoping that you'll find this presentation both enlightening and meaningful to you. Without wasting time, let's go on to look at the next part of our discussion. So, one question that we seek to ask and answer is, what is a contract? And to hazard an answer, would say it is a legally relevant juristic agreement between two legal persons whereby each party binds itself to perform and to receive performance from the other. The parties attach legal consequences to the agreement and anticipate legal remedies in the event of the infringement of the terms of the agreement by the other party. So a contract is distinguishable from a social agreement between two persons, as the latter does not anticipate any legally consequential outcomes from itself. Now, we will discover as we go down in our discussion, when we say a contract is a legally binding agreement with legally relevant consequences as a juristic agreement, we imply that we expect the law to attach certain consequences to a contract, but not to a social agreement or a social, interaction between two people. But without wasting time, we will unravel some of these distinctions as we proceed further. It is rather sufficient for you at this point to know that there are legal consequences attached to a contract. The two parties to the contract undertake to bind themselves and to perform or to desist from performing, and implying that there are outcomes attached to their performance or non-performance, whatever the case may be. The question, therefore, is what is the basis for contractual commitment? What are the requirements for the formation of valid contracts in terms of South African law? That's very, very important. And we've got 5 items here. So when we ask the question, on what basis are the parties bound to contracts, the answers would tend to be, 1, there must be consensus between the contracting parties, which means that there must be agreement between the parties. And then secondly, the two parties must have legal capacity to act in terms of the law. There are people in law who do not have the capacity to act in law. In other words, the law doesn't attach any effect to their conduct or their actions. That's very important to take note. So we have got minors, or we are talking here about children, who usually have limited capacity to act. Then we have got prodigals, or people who can't take care of themselves for one reason or another. And we've got people who are mentally ill. They also lack the legal capacity to act or to perform legally relevant juristic acts. And sometimes we also have people who are insolvent, those who have whose debts outstrip their ability to pay. So those people sometimes have a diminished capacity to act. So depending on the nature of the agreement that they purport to enter into, there may be limitations there. Then there is the issue of the juridical possibility of the agreement. So in other words, parties may not agree to commit rather an offense. They may not agree, to violate the law, if one would say. For instance, parties may not agree to commit a murder. That would actually be in violation of the law. Or there are also some contracts such as gambling contracts and so on, which are also bereft of that juridical endorsement or possibility that can be entertained by the courts. And then there's also the issue of physical possibility of performance. We are saying performance must be possible. As an example, A offers to sell a horse to B for a certain amount of money, and they agree, and then B pays the purchase price. But unbeknown to them, the horse died 2 days ago. So in that case, it is no longer possible for A to deliver the horse to B. Therefore, we are saying in this particular case that there may be physical possibility of physical impossibility of performance. So as we look at other aspects, if you can check some of my videos where we talk about supervening impossibility of performance and other issues, you find that in some instances it may be impossible to perform in terms of a contract. And then we are also going to take note of the fact that the parties entering into a contract must observe certain legally prescribed formalities. For instance, when it comes to contracts regarding the transfer of land or fixed property, such as houses and so on, it is a requirement in terms of law that such contracts must be reduced to writing. In other words, whilst oral contracts are permitted for all other types of contracts, they are certainly not permitted when it comes to contracts to dispose of land and so on. So take note of that as well. So just by way of summary, the 5 criteria that must be met in order for an agreement to be deemed a contract: there must be consensus between the contracting parties. The parties must have legal capacity to act, and the terms upon which they agree is that whatever the objects of the contract, they should be legally possible. In other words, the law must, this must be kind of a performance and obligations that are recognized as lawful in terms of the law. And then the performance must be physically possible, and then there must be adherence to formalities where in fact there are formalities regarding that type of contract. So we are saying different contracts will be treated differently. Some will have strict formalities, others may be concluded orally or just verbally, either in writing or whatever, and some even by conduct, inferring from people's conduct. Yes, that's very important to take note of. We are saying consensus is the critical basis for contractual commitment. There's a statement which says, can two work together except they agree? As you can see from that image, the two can't work together except they agree. So consensus lies at the heart of contract. We have already alluded to that part in the foregoing. Let us look at the aspects of contract in this case. We are saying to ourselves, what is consensus? And in endeavoring to answer, we say consensus is true agreement. Parties reach consensus on the rights and the duties created by the agreement. So the parties must be satisfied. They must both be they must both affirm their commitment to the rights and the duties created by that agreement. And the consensus must consist of objective and subjective elements. What we mean by subjective inquiry, it entails establishing the intentions as they exist in the minds of the parties. It's different from the objective inquiry, which looks into the external manifestations of their actions. Now let's illustrate it this way. If I have an object in my hand, and then I extend my hands with that object towards you, you may not know what I am intending to do, but you could stretch your hands to receive that object, whatever it might be, a gift, it could be a food item or whatever. So if I extend my hands to you, then you open your hands and receive it. They are our subjective thoughts, the thoughts in your head and the thoughts in my head. They are subjective in the sense that there's no one else who may know about them. And people cannot observe our thoughts, but they can observe our actions. So even if, for instance, I later on turned around and said, when I extended that hand with a gift in it, I wasn't giving it to you, but maybe I was intending to use it to hit you because I was angry and I was fighting you, and you then went on to receive it. In that case, the objective or observably, that is the externally observable conduct from anybody observing, could have been that I was giving out because you went on to receive. So the issue of whether I wanted to use that object to hit you with it, or I wanted to give it to you as a donation, or I just wanted to show it to you as a friend, that is subjectively within my own domain and my own space, and you have no way of establishing what I actually intended to do in my mind. So we are saying subjective matters lie within the mind of the one who's doing them, whilst objective matters are observable by third parties. So we are saying that we apply, sometimes the subjective inquiry is applied in assessing whether a contract, whether consensus exists or not. So you find that consensus is reached when parties have the intention to be contractually bound. Now, intention is something subjective. It is inside their minds. We cannot always infer it just by looking at their actions. And we are saying consensus is reached when parties have a common intention in respect of every aspect of the agreement. Again, their actions can be objectively observed. But what is actually happening inside their minds, it may, in fact, not that it may, it is impossible for any other person to know. So in other words, the law cannot then deal and base its verdicts and its observations and conclusions on subjective matters which are peculiarly within the mental space of the one who's doing them. Instead, we focus ourselves on the objective, that is what can be inferred. So if your conduct is such that we infer that you intend to be bound, then that's what the law will accept as your intention. So otherwise, if people were to be left to lean and rely on their subjective persuasions, then consensus would never be reached at any point. So we are saying the intention is clearly communicated by each party in an unequivocal declaration. What do we mean by an unequivocal declaration? It's that kind of a message that comes out clearly to the other observer to say, yes, this is what the other person intends. It should be that way, and it should be straightforward in that sense. The intention to be contractually bound, therefore, we are saying each party must have an intention to be contractually bound, and intentions must coincide in respect of each of the agreement. So if it's an agreement, let's look at a friend who lends his car to another to use over the weekend. We're saying that these people are not concluding a contract, because the two do not anticipate any legally binding consequences for both of them or for any one of them. But what if at the time when friend A extends the car to friend B, friend A believes that he is selling the car, and friend B believes that he is just going to use the car over the weekend and then bring it back at the end of the weekend to his other friend? In that case, then the two do not intend to be legally bound. Maybe one intends to be, but the other does not. So it matters that the intention to be contractually bound must really be present, and each party must have an intention that's very clear, stated unequivocally, and their intentions must coincide. In other words, we can't have a scenario where one believes he's renting a house, the other believes the house is being rented to buy. So in that case, there would be an absence of consensus. And then, so yeah, that's very critical to take note of. So the parties must share a common intention. I think we have belabored that point, that two gentlemen selling and buying a car reach consensus when they both understand the nature of their agreement. If one of the gentlemen believes that he's hiring a car while the other believes that he's selling the car, then the common intention is lacking, and it's very important for us to always take that keep that at the back of our mind, that the parties must share a common intention, and I underline that part. They must share a common intention. And also important is the issue that you see, this common intention must be manifested through their the objectively observable conduct. So parties must be mutually aware of each other's intentions. Each party must clearly communicate the intention to the other. Mere corresponding intentions cannot create a contract. Let's look at the example. Andrew wants to sell his watch to Ben for 500 rands, and at that time Andrew is not aware that Ben offers 500 to buy Andrew's watch. Now, in this particular case, what we are underscoring is the fact that the parties have not communicated this to each other. In fact, Andrew has not communicated to Ben, so he has not made an offer to Ben. So Ben independently wants to buy the watch from Andrew. In that case, then there is no common intention. Each one has their own independent intention, maybe in respect of the same object, but because the intention has not been communicated and they have not engaged on the basis of maybe communicating and discussing and negotiating an intention, therefore that intention doesn't exist, and nobody should assume therefore that there is any common intention between the two parties. Take note of that. It's very, very important. And then then is the issue of an offer and an acceptance. So how does consensus get to be reached? One person makes an offer, the other one accepts the offer. As an example, you see, parties must communicate their intentions through offer and acceptance. We are saying, as an example, right? We give the example of Andrew, maybe, who then goes ahead to approach Ben and says to Ben, I'm selling this watch. Would you like to buy it for 500? So when Andrew makes that statement to Ben, then Andrew is making an offer of a watch to Ben at a price of 500. So an offer is a declaration made by one person who's called the offerer. In that statement or declaration, the offerer indicates an intention to be contractually bound by the mere acceptance. In other words, when Andrew says to Ben, I am offering to sell you this watch at 500 rands. If you are willing, pay the 500 and take the watch. So in that offer, we say it's a declaration indicating an intention to be contractually bound by the mere acceptance of the offer, and setting out the rights and the duty that Andrew wishes to create. So in the offer, it must be clear that he is selling and the other one must buy. And if the one is going to buy, then a payment of 500 rands is going to be included as payment. That's very important to know. So that's what an offer, those are the elements of an offer. And a declaration made by one person indicating an intention to be contractually bound rather by the mere acceptance of the offer by the other, and setting out the rights and duties and obligations that he or she wishes to create in terms of that offer. So an offer then gets to be accompanied by a corresponding acceptance. And what do we mean by an acceptance? So when Andrew offers to sell a watch to Ben, when Ben says, yes, I want that watch, then we are saying that Ben has accepted the offer. So what is an acceptance? It's an unequivocal declaration by the offeree, that is the person to whom the offer is being made. And in that declaration, the offeree agrees to the terms of the offer. He agrees to the rights and the duties and the obligations created by the offer, and then makes a commitment to meet the rights, to meet the obligations, to satisfy the terms of the offer, as it were. So that's very, very important on its own. So what are the requirements for offer and acceptance? Let's explore them. Now we are saying that the offer must be made with the intention that the offerer will be legally bound by the mere acceptance thereof by the offeree. So in the case of Ben, in the case of Andrew says to Ben, I have a watch which I am selling for 500 rands, and I would like you to buy it if you may. So the moment Ben says, yes, I am buying it, here are the 500 rands. There is no way then for Andrew to turn around and say, well, I've made up my mind. So in other words, the offer must be so clear that the offerer intends to be legally bound. He or she is trying to create a legally relevant consequence out of it. And we are saying the offer must be complete. It must not be tentative. It must not be a case of saying, I am offering to sell you my house for 1 million rands, but I'm still going to ask my wife whether she wants us to sell the house or not. That is not a complete offer. Because even if the other party were to offer, to accept the offer and pay the 1 million, that offer is not complete. Because what if the wife does not agree to the sale? That's very important to take note of. So the offer must be complete, and the offer as well as the acceptance must be clear and certain. So the person making an offer must be clear. The person accepting the offer must also be clear. You know, there must not be any equivocation. We must not be left in doubt as to whether there was any intention to offer and to accept. So we are saying offer and acceptance may be made either expressly in writing, that is orally, or tacitly through conduct, through human behavior. So we are going to talk a little more about tacit offers, but maybe as an example, think about this. A man or a woman walks into a local supermarket without talking to anybody. It takes a trolley and pushes it along the aisles, and as he or she does that, he is picking up items from the aisles and dropping them into that trolley. And when he or she is satisfied that he has got enough, she then drives the trolley towards the cashier. And then when he or she gets to the cashier, unloads the stuff onto that table by the till, and then the cashier goes ahead, scans the goods, and then at the end of the day presents a bill to the man or the woman who has been pushing the trolley. And then on seeing the bill, this person who walked into the supermarket then takes out some banknotes or swipes their bank card to pay for the goods. In that case, a contract has been concluded without anyone uttering a word. So those are some of these contracts that we encounter. And we are saying the offer must be addressed either to a particular person or persons in the general, or to an unknown person or persons who are members of the general public. And the offer and the acceptance must be clearly communicated. So you offer to the public or you offer to specific individuals, and then having done so, you clearly communicate your intention with respect to everything about that offer. So you must really be very specific when it comes to that. And so the offer must be accepted. So what does acceptance entail? When we say that an offer must be accepted, we imply that without an acceptance, an offer does not give rise to contractual obligation. So in the case of Ben and Andrew, since Andrew extended an offer to sell a watch to Ben, if Ben does not respond by saying, oh yes, I want that watch and I'm going to pay for it, and here is the money to pay for it. If there is no such response, then the offer has not been accepted. So it gets accepted when there is that unequivocal communication, as we have said, by the offeree to say, yes, I am accepting what the offerer is giving to me, or the offer that's being extended. Then a contract comes into effect immediately. And then the offer does not remain open indefinitely. That's another very important point to take note of. So at some point, the offer will have to come to an end. Yes. Before you even look at the ways or the methods in which offers come to an end, let me highlight maybe another point which is covered in another video that you may have to follow up on. We are talking here about how the offer gets to be communicated. We said that it could be verbal, it could be by way of a letter. Maybe Mr. X, who's in Cape Town, writes a letter to Mr. Y, who is in Durban, offering to sell his car. So there is here the issue of who the offerer is. Obviously, the one in Cape Town who's selling the car is the offerer, and then B, who's in Durban, is actually the offeree. So they are using the letter as a means of communication, or they could use a phone, they could use an email, and so on and so forth. There are rules regarding, you see, the offer and acceptance, particularly between people who are in remote stations, far away from each other. So the question would be, when is the offer made? Is it made when the letter is written or when the letter is posted? Or is it made when the letter arrives at the destination of the person to whom it is being written and being posted? So that's a very critical question, because it determines a lot. Suppose the offer, the letter is posted at Cape Town, and then it takes 2 weeks to get to Durban, and in that period, Mr. A, who had made the offer to B, decides that he is no longer selling the car, maybe because he thinks he wants to keep it as an antique, or he wants to donate it to his son and so on. So the question then is, does the offer still stand? When B in Durban receives that letter, is A then bound in terms of the offer, since he has changed his mind? Or alternatively, maybe B receives the letter and decides, oh yes, he wants to buy the car, and writes a letter in response and posts that letter. So has the offer been accepted already? What happens if that letter gets lost in the post office and never arrives? Or alternatively, another question, what happens if maybe, as we had said, by the time the letter gets to Cape Town, Mr. A has already donated the car to his son, and B now is laboring under a misapprehension that since he has accepted the offer, the only thing that he now awaits is its delivery of the vehicle. Maybe he has even written a check and sent it by post, or he has, paid through an electronic funds transfer system, or whatever method of payment. So does the offer still stand? Has the offer been properly accepted? Is it still valid? So is anyone now bound in terms of the law to perform in terms of this offer and acceptance? So those are some of these very critical questions, especially now with the advent of what you call this, your internet, the proliferation of these electronic means of communication, your internet, your emails, your EFTs, and so on. The questions then around when the contract gets to be concluded, when the offer gets to be accepted, they do arise. Of course, even in common law, there were questions around the issue of the offer and the acceptance, theories like we will look at some of these theories maybe just in a moment in the next slide. So we have theories on offer and acceptance. These theories may be classified into two. We have, in fact, there are two types of acceptance occurs in two ways. We have parties who are within each other's presence. For instance, these two parties are sitting side by side at a restaurant. An offer is made to sell a car, and then acceptance follows immediately while the people are sharing a meal. So they are within each other's presence. That's not a problem. What about parties who are not in each other's presence? We gave the example of a letter that is sent, or an email that is sent and received and responded to. Would we say that these parties, the rules regarding offer and acceptance should be the same? Certainly not. So with regard to parties who are within each other's presence, we have the ascertainment theory, whereby we are saying when A makes an offer to B, the contract comes into effect. Immediately A becomes aware that B has accepted the offer. So as long as A is not aware that B has accepted the offer, then in terms of that theory of ascertainment, there is no contract. But we have these remote collaboration tools like the telephones, like the Zoom meetings, like you have your teleconferencing, video conferencing programs, applications. So you find that with those, it's not problematic because people can speak and share ideas and views and exchange positions in real time. But what about maybe scenarios where there's no synchronous communication? Because as we have said, the synchronous communication, the advantages offered by telephone as well as by these video conferencing platforms, they bring that advantage of immediacy. But the same cannot be said maybe regarding the letters and the emails, which for which there is a time lag between the time maybe the offer is made and the time is accepted, and the response, the acceptance of the offer, and so on. So there are two theories then that have been developed to deal with this. There is what is called the dispatch theory, and there is what is called, well, the expedition theory. People talk about the posting rule. And so they say that communication by post or telegraph is not a direct communication. So in that case, you find that the offer and acceptance is guided by the expedition theory, where we are saying that as a general rule, there is no immediate ascertainment of the acceptance. So in terms of this dispatch theory, the contract is concluded at the moment when and at the place when the letter of acceptance is posted. So get back to our example on A and B, where A is in Cape Town and sends a letter to B, who's in Durban, offering to sell a car to B. So we are saying that when that offer is accepted, when B posts a letter in Durban to respond to A's offer, who is in Cape Town, then that moment when that letter is posted there in Durban is the time when the contract comes into effect. So because the contract has come into effect in Durban, this determines issues of jurisdiction. When the two have a dispute about whether the contract ever took place or not, or any other issues regarding the performance in terms of that contract, you find that the court in Durban is the one that will exercise jurisdiction over that contract. Because remember, contracts are subject to jurisdiction, and the jurisdiction is determined by the place where the consensus or the agreement was reached. So because of that, you will then realize that Durban will serve as the court endowed with the jurisdiction to hear any dispute in connection with that contract. So that is in terms of the expedition theory. And let me just underscore again the fact that the expedition theory applies in the sense that because those two people are not within the same geographical place, they are not at each other's presence. Of maybe let's leave out the issue of geographical space, because we did say earlier on that in the case of telephone, where there is synchronous communication, people exchange ideas and positions in real time. That one then is dealt with on the basis of the ascertainment theory, whilst the other one where the parties are not within each other's presence, then the solution is sought in terms of the expedition theory and the dispatch theory. That's very, very important for us to really take note of. So that's as far as the theories on offer and acceptance. But we were going to then look at when the offer lapses, because we said earlier on that an offer does not remain open indefinitely. So then let's look at under what circumstances it can lapse. So the offer falls away under a number of circumstances. It falls away if it stipulates clearly and expressly that it has a particular lifespan. If it stipulates that it is valid for a specific period of time, then it expires when that time arrives. For instance, imagine that Miss X applies for a job at a company, and then they offer the job to Miss X, but they say to her, you must respond, you must accept the offer in the next 7 days, 7 working days, or 7 calendar days, depending on whatever the letter says. Now, if that period elapses without Miss X communicating her acceptance of that offer, then it falls away. It means that the company offering the job position is no longer, held liable for maybe for in terms of that offer, because the person to whom it was offered has not accepted it. Sometimes you find that the offer is revoked by the offerer before acceptance. You remember this what we said about Mr. A, who is in Cape Town, who writes a letter to B in Durban offering to sell his car, and whilst the letter is on the way, Mr. A then decides that he's no longer selling the car, but he's going to donate it to his son. Then that offer has been revoked in a way. So, but then maybe he may have to write a letter to B, to inform him about the revocation of the letter, of the offer, so that B then gets to be adequately informed that the offer doesn't stand anymore. Or if the offeree rejects the offer, so in the case of A writing a letter to offer his car which he wants to sell to B, if B says, no, I don't want to buy the car, then the offer has fallen away. No one is bound. It also falls away if the offeree offers a counter offer. Right? Look at this. Mr. Andrew says to Mr. Ben, I am selling a watch for 500 rands. And then Mr. Ben writes back or says to Mr. Andrew, yes, I want to buy that watch, but I'm going to pay 650 rands for it. Or he says, I want to pay 450 rands for it. Whichever figure, whether it's higher or it's lower. It is not an acceptance of an offer, but it is a counter offer. So the issue now is that a counter offer cancels the offer, because now Andrew had been the offerer holding the watch. Now, when Ben says, no, I'm not going to buy it at that price, but I've got a proposed price, it is now Ben who is offering to Andrew. So it's a counter offer. So a counter offer is a declaration which does not unequivocally accept the offer, but instead of accepting, it presents an alternative. So on that note, the offer lapses, it falls away. Or in some cases, the offerer or the offeree may die before the acceptance of the offer. So under such circumstances, then we notice that the offer has actually lapsed. So death has the effect of cancelling or doing away or eliminating the offer altogether. I hope that is understood. Yes, I think this then brings us to the end of this video. But before we do that, let's just round things up. Right, as our conclusion, let us remind each other that we began by defining a contract as a legally relevant agreement between two people whereby they commit themselves to the consequences, legal consequences that attach to rights and obligations being contained in the terms of that agreement. And we said consensus, among other factors, was the backbone. We said consensus was the backbone of a contractual agreement. And we are saying consensus is a critical basis for contractual agreement or commitment. It is, in what we mean by consensus is true agreement, whereby parties to the contract must have the intention to be bound, and the consent must be properly obtained. If it is not properly obtained, then that consensus does not exist. In fact, it's a kind of a dissensus. So consensus is not the only basis, of course, for contractual obligation. There could be other, considerations, public policy considerations, and so on. But suffice it to say that consensus lies at the heart. So we do have a video lecture on, factors that may vitiate or eliminate consensus. I would suggest that you give yourself time to look at those, to watch those, so that then you get yourself equipped on what we are talking about. Once again, thank you very much for being part of this presentation. I hope it has actually enriched you and enlightened you. For me, I've had the pleasure of making it. I had a similar video some time ago, and then I have since decided that maybe it's time to revisit some of those issues. Remember again to subscribe to my channel, to share the channel with your friends, to hit that notification bell, and to continue to follow me on this platform. Thank you very much for your support. May God bless you.